So thank you everybody for joining our webinar, the False Claims Act in 2025, Staying Ahead of Changing Enforcement Priorities. The webinar is being presented by two of my terrific colleagues here in Saul Ewing's White Collar and Government Enforcement Practice, and I will introduce them in just a moment. The webinar provides an overview of the FCA's framework, highlights recent legal developments, and offers practical insights into the government's current enforcement priorities. My name is Justin Danilewicz. I'm a partner and chair of the White Collar and Government Enforcement Practice at Saul Ewing. I'm based primarily out of our Philadelphia office, and I'm joined by my esteemed colleagues, both members also of Saul Ewing's White Collar Practice. L. Chakravarti is a partner based in our Boston office. L is a former federal and state prosecutor, and among his most notable cases in government was his prosecution of the Boston Marathon bombing. Jason McElroy is the managing partner of our Washington, D.C. office and has extensive experience in the defense of False Claims Act cases across a variety of different industries. I look very forward to hearing from both L and Jason today and learning from them. And before we get to that, and the substance of the webinar, I need to just address a few housekeeping matters briefly. Questions can be submitted through the Q&A tool at the bottom of your screen. The presenters will do their best to answer all questions submitted during the webinar, but are also happy to follow up individually via email if necessary. And of course, please feel absolutely free to contact Elle and Jason post-webinar as well for any follow-up discussion. CLE credit. This program is eligible for one distance learning substantive CLE credit in a number of states. In order to verify your participation and receive your certificate of attendance, you'll have to complete a brief CLE verification survey. And you also have to note the numeric codes provided during today's webinar. These codes are required for you to get credit, and they will be announced verbally by the presenters. The verification survey link was included in your reminder email. It's also linked in the resources tab found at the bottom of your Zoom screen. So please be sure to complete the survey within the next 5 days. The webinar recording and handouts. In the next few days, you will receive a follow-up email that will include links to the webinar recording, supplemental presentation materials, and CLE information. We will not be sharing a presentation during today's program, but the slides are available within the resources tab of the webinar. A short legal disclaimer. The provision and receipt of the information in this program, A, is not legal advice, B, does not create a lawyer-client relationship, and C, should not be acted on without seeking professional counsel who have been informed of the specific facts of a matter. That said, please do consult Elle and Jason as soon as the webinar is done. They're eminently qualified. And with that, I'm pleased to turn the webinar over to Elle and Jason to begin. I know we'll all enjoy and learn a lot from what they have to say. Over to you guys.
Thank you, Justin. I'll get us started. If we can get the next slide. We recognize that there's a wide array of experience and exposure to the False Claims Act. And so we're going to try to find that Goldilocks environment of maybe a little more general than some would prefer, but a little more kind of in the weeds than some may be prepared for. So we'll start with just an overview of what the False Claims Act is for those who are uninitiated, or it's also a good reminder, particularly as you'll see there's a theme in our presentation about kind of revisiting the False Claims Act, both by the executive branch and how it's going to be used, as well as by the courts and what aspects of it are lawful or not, and how to perhaps refine it. You should all know that the False Claims Act has been around, it's known as the Civil War era act that was sometimes called Lincoln's Law for fraud upon the government for submitting false claims for reimbursement during the Civil War. And it's been around, obviously, for 150 years, and it was really only recently energized both in the late 80s. You may remember the $400 hammers during the Reagan administration. Um, and then again, more recently, post uh, global financial crisis, when you'll see that there were some cases and some legislative action as recently as 2008, 2009, that really made DOJ use this tool to try to recoup funds and also to be somewhat punitive. And that is obviously one of the aspects of the False Claims Act, which makes it different from a regular civil cause of action. We put some numbers up here. The others are available, uh, and they've kind of ebbed and flowed. But in general, the trend has been that DOJ is recouping more and more money through False Claims Act for disbursements of federal funds to either improper recipients, other recipients who committed frauds, recipients who may not have reported all of the fees that they were obligated to provide to the government, and a variety of other kind of claims, such that this past year, 2024, there was a record number of the key TAM variety of the False Claims Act cases, which we'll talk about in detail um, in a few minutes. But the key TAM relators of the $2.9 billion that was recouped by the government last year, the key TAM relators personally received $404 million. And that is really why this is now open season on on false claims, because relators are getting energized, the government is more encouraged to bring these cases, and there is an incentive now to find some kind of false claim where for years there was really very little personal incentive to do so. The False Claims Act is investigated by DOJ, uh, and when DOJ is involved, there can be civil enforcement as well as criminal enforcement. And so there can be circumstances, particularly in the healthcare fraud arena, where we have seen civil investigations turn criminal because of, for example, a violation of the anti-kickback statute or the like. Next slide, please. There are other statutes which are similar to the False Claims Act, which is a federal statute, obviously. There are state False Claims Acts, which have very similar elements. They basically are trying to get to the nub of someone submitted a claim to the government that either was a false claim, wasn't justified, or there was a materially false statement or a record submitted in support of that claim. And some of the states that have enacted these statutes have actually limited types of fraud, which can be addressed through the state claim, and others have more broad types of fraudulent conduct that can be addressed, including potentially tax fraud, for example. I'm thinking of New York in the circumstance. In addition to the state laws, which we have seen some state attorneys general become more energized in this new climate, but I think by and large, it's the federal government that is wielding this tool now more prolifically than they ever have before. There is also another type of administrative structure through which the federal government can also seek to recoup funds that should not have been dispersed or to which they're entitled, and that's through the Program Fraud Civil Remedies Act, which is generally for more de minimis types of offenses. And in those are cases where DOJ has explicitly said, we don't want to handle it. Why don't you try to recoup it? There is a kind of a whistleblower incentive for that as well, but it is less so than in the key TAM circumstance that we'll describe in a moment.
Yeah, and just quickly, Al, on the PIFCRA, the Program Fraud Civil Remedies Act, it's important to note too that you know where DOJ declines, the agency itself is actually the one who brings those claims. They bring it in their administrative tribunals.
Right, right. It's an admin kind of procedure, which means that you're kind of beholden to them much more than if you were to get before a court. Next slide, please. So these are the elements of the False Claims Act. claim. So this would be a cause of action either filed by the DOJ or filed, as we'll learn, by a relator in a key TAM case on behalf of himself and the government. But they essentially require these elements: that there has to be a false or fraudulent claim. And that means that either the claim for payment or uh, the, uh, the the document that is sent to the government saying we are entitled to payment uh, is is either false on its face, or if there is false information being submitted in support of the eligibility, for example, for that payment. Importantly, over time, uh, this has been interpreted not only to mean a false claim submitted directly to the government, but also if it is submitted to a contractor or somebody else for ultimate submission to the government. That essentially what we call a derivative federal payment also could constitute a false or fraudulent claim. The second element is scienter, which is knowledge, and that's required in virtually every type of cause of action. In these cases, uh, they must have acted knowingly, and that means actual knowledge, or as often is the case, whether there was some putting your head in the sand, whether there was a deliberate ignorance of the truth or reckless disregard of the truth. And there has been some law based on various fact patterns that questions where along that continuum some entities' knowledge may have been. Importantly, as we'll hear in recent cases, the Supreme Court has indicated that what matters here is the subjective knowledge of the entity or putting in the claim, as opposed to what the objective, reasonable person's knowledge ought to have been. Materiality is the other very key element frequently litigated in these cases. It's whether what was submitted that was allegedly false, whether it really would have made a difference to the government's decision to pay the claim. And we'll hear about the case law in that has developed as to whether there was more than a mere possibility that the government could have acted, or whether it really was fairly within the government's ability to deny the claim if they had known all of the true facts. And then, of course, the idea of causation, which is an element of any kind of case where it's because of the false claim that the government paid out the money. A final point is this idea of a reverse false claim, which is when someone is not paying the federal government because they're claiming some kind of an exemption. An example of that is in the recent tariffs. If tariff increases, if someone falsely submits a document to the government in the hopes of avoiding paying certain tariffs to the government, then that could be considered a theory of a reverse false claim because they're knowingly concealing or avoiding an obligation to pay the government. And I'll turn it over to Jason for the next slide.
Yeah, so as we talk about a little bit more of the background, what to think about in terms of what is the False Claims Act, the statute of limitations is a big issue and has been litigated a lot over the past few years, probably 10 to 15 years. In the early 2010s, there was a lot of litigation on whether or not what is known as the Wartime Statute of Limitations Act actually extended effectively indefinitely the False Claims Act statute of limitations. That was a position the Department of Justice was taking for a while. That, luckily, the Supreme Court stepped on and said, no, it doesn't, the statute of limitations does not effectively extend indefinitely, because the Department of Justice back then was saying that the authorization for use of military force in Afghanistan and Iraq, which some of you may be aware, at least for Afghanistan, is still in effect today, extended effectively indefinitely until that AUMF was stopped. So that was a position the DOJ was taking early 2010s, shortly after the financial recession, the financial meltdown. And the Supreme Court said no to that. But a couple more cases have come up on the statute of limitations, and it becomes really important with what the language is here. The statute of limitations says not more than 6 years from the date of the violation, or not more than 3 years after the date when facts material to the right of action are known or reasonably should have been known to the United States, to the person who was responsible for it in the United States government. And the important part of that is whichever occurs last. So effectively, you could have something that happened, you could have knowledge of the government only occurring 7 years after the date of the violation, and that's when that 3 years starts to run. So you could have it 8 years or 9 years too, but then you start running into the next part of the statute of limitations, which is really a statute of repose. And that is no action can be brought more than 10 years from the date of the violation. So the statutes of limitations are tollable. Statutes of repose are not. Statutes of repose are a hard deadline. So the statute of limitations in the False Claims Act is fluid. And you see this become an issue in many investigations and in many actions because a lot of times knowledge of the particulars of what the government believes is a fraudulent scheme or is a scheme to violate the False Claims Act don't come to light until well after the occurrence of the potential violation. Next slide, please. So how does a False Claim Act start? Typically, you see two different ways. You see either a qui tam filing or you see an independent investigation by a government agency, whether it's the Department of Justice or whether it's the agency that controls the program that you're dealing with. The vast majority of the FCA claims that we see come from qui tam relators, come from whistleblowers. Now, qui tam is just a short term for a longer Latin phrase that effectively means he who brings on behalf of the king, or he who brings on behalf of the regent, the king or queen, and was fairly common in England prior to this founding of the United States.
Jason, can I just interrupt there?
Yeah, of course.
Maybe for some comic relief for the lawyers on the call. The Latin phrase actually includes virtually every legal term that you've ever heard that has been taken from the Latin. I'll just read it here. It's qui tam pro domino rege quam pro se ipso in hoc parte sequitur, which it sounds like a Mad Lib for Latin.
And I'm much more boring than that. I'm a Latin major in undergrad, so I actually know how to conjugate and decline all of that, Al. But the main point is that basically what it means is that an individual who can bring a claim on behalf of the government. And it started by, in England, they had these claims where individuals could bring on behalf of the government, on behalf of the king. And now this is going to become important. The way that came into US law is going to become important because Al's going to talk about some challenges to that later on in this presentation. But for right now, for purposes of just what is a qui tam claim, just think of it as a private individual. It can be a corporation. It's rare to see it as a corporation, but you do see it sometimes. But a private individual who is bringing a claim on behalf of the government. So it's really the government. The private person stands in the shoes of the government. And when a qui tam relator, we call them relators, not plaintiffs. When a qui tam relator files an action, they have to file it under seal. And they have to file under seal because the government gets first dibs on that. They get a right of first refusal, if you will, on bringing that claim. And they have initially a 60-day time period in which they can investigate and determine whether or not to what we call intervene in the case. So when the government decides to step into the case and take it over from a qui tam relator, we call it intervention. And when they decide not to do that, we call it a declination. So an intervened case means that the government didn't start the case, a qui tam relator started it, and the government then decided to take it over. A declined case is one where a qui tam relator started it and the government decided not to step in. Typically, there are no adverse inferences that can be taken from the fact that the government decides not to intervene in a case. the vast majority of these cases, whether or not the government thinks there is merit to them or not, the government just doesn't have the resources. I mean, you saw in Al's in the slide earlier, Al said there were somewhere on the order of 980 key TAM cases filed under the False Claims Act last year. I mean, that's a huge number on top of the numbers of the cases that those prosecutors are already working on. And you think about that year over year, that number of cases being filed, they just don't have the resources to handle every single one of them. So some of them get declined, and that's the reason that the key TAM provision is there, so that when the government doesn't have the resources or the ability to prosecute that the way that they normally would, the key TAM relator can. And the way that the statute is set up is the key TAM relators have incentives to do it. The key TAM relator can get anywhere between 15 to 30% of the recovery, of the final recovery, and the attorney's fees are on top of that. So they don't come out of the recovery. They're on top of that. And the defendant who settles or loses a trial, either one, has to pay those attorney's fees to the relator's attorney. So there are huge incentives for key TAM relators and key TAM relators counsel to bring these cases.
Yeah,
So,
one other thing to just add to that, Jason, even if the government chooses to decline to intervene because of the demands on their time, it doesn't mean that they're not paying attention to what's going on in the case. And after the 60 days, if there could be reason why they get more interested in it, so that there's always this risk that they're going to kind of want to butt their heads back into the case. Similarly, because the suit is brought on behalf of the king or the government as well as the individual, they get a say in some of the settlement discussions as well. So it's not like they're ever really out of the case in these cases, but they're not the ones prosecuting them in the majority of cases where there's a declination.
yeah, that's a great point, Al. Is anytime you're trying to settle a False Claims Act case, if a relator is leading it up, you still have to get the government's approval on that. So unless the government signs off, you're not going to be able to get that case settled. And typically, once you come to the place where you're thinking about settling, you should be having those conversations with whoever the AUSA or the Department of Justice representative who's maintained a presence in the case about those settlements, so you don't get bad news you don't get down the line, have an agreement with the relator, and all of a sudden the government says, no, this settlement's not going to work for us. So as I said, the key TAM relator provision, that brings the vast majority of the FCA claims, but there are independent investigations and brought by individual agencies who then refer to the Department of Justice. Sometimes you'll see some of these beginning in an Inspector General's office as well. Next slide. So what are the significant areas of FCA enforcement that we see? We see it in Medicare and Medicaid is probably the largest group that we've seen year over year, right? Government contractors are a big one. Anyone who sells things to the government, obviously government contractors are doing that. Mortgage insurance was a huge focus for the False Claims Act in the 2010s, shortly after the recession. So you had the FHA Mortgage Insurance Fund, you had the VA Mortgage Insurance Fund. These were two large government insurance payouts where they went after, both key TAM relators and the government went after mortgage originators. We've seen universities be subject to False Claims Act claims in the past for a variety of different federal funds that they have. And Al is going to talk a lot more about the task force that the government has set up, where we think they're likely looking at universities now as well. Pandemic fraud has been a big one. The PPP program, the Paycheck Protection Program, has been a big source of investigations. However, the numbers that you see with the PPP program tend to be smaller than with other programs, simply because the Paycheck Protection Program had a cap of $10 million that you could get from that program. So typically, what you're seeing in terms of the the Paycheck Protection Program investigations are smaller numbers, smaller companies being investigated than you see in the government contracts world and typically the Medicaid world. And then we have a couple of new initiatives as well that we think we're going to see a lot of. We started to see a lot in the Civil Cyber Fraud Initiative. That was a big push in the last few years. We're starting to see settlements come out of that, and customs and tariffs with Liberation Day a few weeks ago, and with all the tariffs that we're now dealing with. This is a big potential area of False Claims Act liability. And with that, I'll turn it back over to Al for the next slide.
So there are many different kind of legal theories on what constitutes a false claim. They all revolve around whether the claim itself was fraudulent or whether there was false information submitted in support of the claim. For this discussion, I think we broke out kind of the three main theories, which are that the claim itself was factually false on its face. The second is whether it was legally false or there was a false certification. And there can be an express false certification, like somebody, a president, CEO of a company or an entity signs saying, I certify that this is true, and it's not true. Or the implied false certification, which a Supreme Court case basically kind of supported as being a legitimate theory, which is that there was a certification that you're going to comply with the laws, essentially. And over time, that certification was contravened by the practice of what the entity was doing. And in so doing, every time they were getting reimbursed, they were failing to comply with that contractual condition that they had previously certified to. And this is known as the implied false certification. And then there's this idea of promissory fraud or fraud in the inducement. And that's where the extension of the contract, for example, based on that initial false statement, it could be considered a promissory fraud, because it's a fraud. You promised essentially that you were going to comply with these laws, and then over time you fail to do that. And so you can see that there is often an overlap between the implied false certification and the promissory fraud theories. And because these are alternate theories, the relators often want to kind of hedge their bets and allege both of them, hoping that different facts would help support each one. And so you might imagine that in a promissory fraud case, you might get much more discovery of the initial certifications and the initial representations versus in a false certification case where it would be much more narrow to what the alleged falsehood was.
Yeah, and
Go ahead.
It's often hard to find the line of the to differentiate an implied false certification claim from a promissory fraud claim. And we mentioned the Ninth Circuit Hindow case in the citation here, and that case kind of sums it up. I mean, if you read that case, they really bleed together. The Ninth Circuit does not really find a distinction between the two theories. And I think that's largely where it has gone now, because if you look at an express false certification claim, that's pretty clear what's happening there, versus because you're saying, all right, there's a certification that you made and it's false, and you're certifying that you complied with some regulation or some contractual condition. It's not really that far off from a factually false claim, right? Whereas the implied false certification, promissory fraud, require these leaps of inferences in between different steps, where you don't necessarily have the express falsity, but you're implying falsity from some behavior. You're implying really fraud on the front end. So it's really hard to make a distinction between those two theories sometimes.
Yeah, for sure. Next slide, please. So this is me, I think. So let me at the outset, before I get into the Escobar case, give the first CLE code. It's on the screen. again, if those of you who are applying for CLE credit, it is 85126, 85126. So the Escobar case, almost 10 years old now, 9 years old, was a case where a woman died in the care of a facility, and the relator brought suit against the facility, saying the facility's staff actually hadn't been appropriately qualified pursuant to the regulations. And because they hadn't been appropriately qualified, in light of what happened to her own daughter, that all of the claims they were submitting for reimbursement from CMS and from the federal government were false claims. And uh, it was basically this false certification theory that they said they were telling the government that they were appropriately certified staff, and yet things transpired after the fact that demonstrated that maybe they weren't. And Escobar articulated the standard of materiality that for a claim to be actionable under False Claims Act, it must have been able to make a difference in whether the government was going to pay that claim. And what does that mean? Well, they said it was a rigorous materiality standard, but obviously these are going to be fact specific. And the what they articulated was that non-compliance would actually have mattered to the government's decision to pay. So in that case, if the government knew that these weren't qualified staff members, then it stands to reason that they would not have paid or reimbursed the facility. Next slide. So what emerged from Escobar was a number of cases. Almost every case for the last 9 years has tested whether that materiality standard was met. And some are on the screen. The Stevens Institute was an art academy, which was alleged to have not complied with the incentive compensation ban that exists in higher education under Title IV for getting federal funds. There was a Northern Adult Health Care Center and the Genentech case, both of which showed that the government, the federal government, in faced with the same information in other cases, was continuing to pay out, which was undermined the materiality of the alleged false claim. Because if the government knows that this claim is being made under these circumstances and for other defendants is not taking action against them and is continuing to pay, then that certainly goes to this issue of whether it was really material to the government's decision to pay or not. Next slide. And so what has emerged after all these cases is essentially a circuit split. And obviously that's a red flag for the Supremes wanting to be interested in this again. But some circuits have taken this position that when Escobar says there's a rigorous materiality standard, that it means something more than just saying that it could possibly have made a difference, but rather that there has to be very strong evidence, or that the government would have essentially not paid this claim if they had known the information. And the Third Circuit, DC Circuit, are both circuits in that vein. Other circuits have taken a more lenient approach. List the Second and the Ninth here, which basically has allowed cases to survive the summary judgment phase, simply if there's an allegation that there was more than this possibility, more than a mere possibility that the government would in fact have been entitled to refuse payment if they were aware of the alleged violation. And so in some cases where you choose to file the case makes a big difference into the application of the materiality law. And as Jason said earlier, materiality is one of the battlegrounds on which these cases are often fought on factually and even in the summary judgment phase. And so there is an increasing willingness of relators to go to the the districts where they have good relationships with the DOJ and where they may have favorable law, particularly in terms of this materiality decision. Next slide, please. Jason, you want to take this one?
Sure. So the next big holding we're going to talk about is the super value case, which gets down to scienter. So Escobar was a huge ruling on materiality. Super value was a huge ruling on scienter. And these two things, just see, we're going to talk about this a little bit more in a few minutes. These two concepts are really kind of inextricably intertwined because theoretically you can separate scienter and materiality into, all right, materiality is something that, in the mine run of cases that the government would care about in its decision to move forward in the program and pay out. That's one of the primary takeaways from Escobar. And scienter comes around to you have a lot of situations where you're trying to prove what the government knew and what the government didn't know ahead of time. That applies to materiality because it applies to, well, was it material to their decision? But it also applies to scienter because if the government knew what you as a defendant in a False Claims Act case were doing, how do you have the scienter? How do you know that what you're doing was wrong when the government knew about it and allowed you to move forward? So there's a real intermixing between the facts that go into these two concepts. But scienter, as Al said, you have three different ways of identifying scienter. You have willful knowledge, you have willful disregard, and reckless disregard of the law, which is effectively negligence. The last level is effectively negligence. And until 2023, most people in the False Claims Act bar, at least most defendants in the False Claims Act bar, really fought hard on what the definition of that scienter, that lowest level of scienter, was for negligence. And there's a case from the Supreme Court around 2000 called Safeco that effectively said that you had to have no objective belief that what you were doing was correct, or there could be no objective belief of what you're doing was correct. So what happened in the super value case was in the Seventh Circuit found that there was an objective explanation, objectively reasonable explanation for what the defendants had done. But in that case, the defendants had a subjective belief that what they were doing was wrong. So the tension was, is it objective or is it subjective? That is, if you have the reasonable man standard, the reasonably objective person looking at this, what would they think versus what the person who actually was doing it thought? And so the Supreme Court in the super value case said, no, it's subjective. It's what the actual defendant actually thought. Did they think they were violating the law? If they thought they were violating the law, then scienter is there. Next slide. So the implementation of this has been important because of this added emphasis on the subjective knowledge and subjective intent. It emphasizes really the importance of the company's subjective understanding of its compliance with the laws that are at issue. So whatever your program is that you're dealing with, your subjective belief of your compliance with those requirements is super important. And that's why, we talk about the materiality and how the government's knowledge and everything that goes into what the government knows about the claim is important. It's the same here on Scienter, a little bit switched though, because it's about the defendant. What did the defendant think they were doing? Did they think they were doing this right? Did they think they were doing this wrong? And that's how we get to such fact-intensive discovery, fact-intensive developments in these cases. Next slide, please. So Al, why don't you pitch in here on the—
Yeah, I mean, as you just explained, Jason, like there's a lot of squishy stuff here. If you are in-house at at an entity that gets federal monies, it's hard to make decisions based on what might be a subjective knowledge, what might be material, and the eye, it's all frequently in the eye of the beholder. So, uh, what an individual whistleblower or relator might think might be at odds with what the company thinks. And more importantly, what we're going to talk about now is what the DOJ thinks may be very different than what the entity thinks, and they have a lot uh, of leeway to be able to push these cases, even short of getting to a trial or to getting to a judgment, but just giving it legs to test whether there is materiality and whether there's scienter. And so we're going to burn through kind of a little bit of the history of how DOJ has kind of come up with its posture. And as we're now in the sixth month of the new administration, we have seen that the posture is different now than it ever has been before. And the False Claims Act has been re-energized explicitly and in practice. And so, going back to the first Trump administration, there were a series of DOJ memos that, in some, made it look like there was going to be less False Claims Act actions and more declinations and maybe even dismissals of these actions by the government. Um, there were specific policy priorities that were articulated both then as well as now, which we'll talk about. And then we'll talk about kind of some of our observations in our practices where we're dealing with uh, uh, many cases across the spectrum in the FCA space. So next slide, please. So former Attorney General Jeff Sessions, he had articulated when he first came in, you'll recall he was the first Trump Attorney General. And when he came in, he basically said that all these agencies that have been implementing various regulations where federal government funds are going out and getting paid for various services or for financial aid or for medical reimbursements, they're often modified by what the implementing agencies, their guidance about what priorities are, where money should go, what kind of programs you should have in place, even though they did not have the force of regulation, they didn't have the force of rules. And again, this signaled that the new administration then thought that FCA enforcement has gone awry and it's been too aggressive and they need to tamp back. The next slide shows that the then civil enforcement chief at DOJ, Mike Granston, he articulated several factors which went a step further and said, in these circumstances, the DOJ ought to consider dismissing the case. And those circumstances are there. So again, giving some safe harbor for a prosecutor who says, you know what, this is one of those cases where we not only should not intervene, but that we shouldn't burden the government, the courts, and ourselves and the defendant, and we should just have the case dismissed. Next slide.
Yeah, and on the Granson memo, just quickly, some of this stuff came up again, and we'll talk about it in a few minutes. In another Supreme Court case, came to a head on the Department of Justice and the executive's ability to dismiss cases as stated in the Granson memo.
That's right. And so then shortly thereafter, Assistant Attorney General Brand again rearticulated that these guidance documents, the more soft instructions of what the administration's priorities are, that they wouldn't be used to be enforceable as a basis of policy for false claims, but they still could be used as evidence of what you knew essentially and what you did about it. And all of that, all of the Trump era DOJ guidance on softening the False Claims Act was essentially undone in the last administration when Attorney General Garland comes in and basically says that we're going to rescind all of that guidance. So we're not sure what to make of that as we sit here today and now the Trump 2 administration. But another factor to consider is that the Supreme Court in this intervening time has opined that even if you have a regulation, so has a force of implementation as a regulation that post Loper Bright, that the historical Chevron deference is kind of is changed. That in that context, one would think that there should be even less deference to what these agencies' guidance might be if it's in just kind of a loose memo. But that doesn't necessarily, characterize the current environment. If we can get to the next slide. And that's because in this administration, the administration has very clearly indicated that it has specific enforcement priorities. Attorney General Bondi issued a raft of memos when she took office. And amongst other things, she made very clear that there's going to be support for qui tam whistleblowers, that they want to pay out monies for kind of open season for finding false claims. There will be an emphasis on False Claims Act enforcement. And then she specifically addressed certain topic areas. And this goes back to like, what is the probative value of her addressing these this enforcement area priorities if they've already kind of said that guidance doesn't really matter in terms of what of these false claims. And we're here to tell you that it does matter, and it may matter. It certainly matters right now because this is the administration in power. But some of the areas that they address are, DEI, diversity equity programs, gender transition treatment programs, anything involving a false claim to a federal health care program. And she also said that she's committed to defending the False Claims Act's constitutionality, which we'll get to in the last 15 minutes that we have. They also announced the Civil Rights Fraud Task Force, which we have seen, and they announced that they would be going out to various universities and other places that have potentially, arguably discriminatory practices, some of which may have been specifically encouraged in the prior administration in order to increase diversity, equity, and inclusion. And that'll bring us to kind of what we're seeing out there in the wild. Next slide, please. Jason, you want to talk about these areas?
Sure. So we're looking at what are we seeing today? Healthcare is always a big priority. It continues to be a big priority. And the Department of Justice has confirmed that recently. But Pam Bondi, our current Attorney General, has a history of being very aggressive in healthcare fraud prosecutions from her time as the Florida Attorney General as well. It makes a certain amount of sense in Florida. Florida's a huge, I mean, every state's a huge healthcare state, but Florida in particular has a big Medicare and Medicaid presence, given the large retirement community down there. But we see a big focus on Medicare and Medicaid. Government contracts are always there. Some of the bigger recent announcements we've seen have been in government contracts. In universities, as Al said, we've seen already what the administration is doing generally in terms of its engagement with universities, and they use engagement almost as a euphemism there. The way that those interactions have gone with the government since the Trump administration took over. But that's an area where they specifically identified in their statements that they're looking. They're looking in both healthcare and toward universities in terms of diversity, equity, inclusion, and discriminatory requirements, the way that this administration views the implementation of those. And that's going to be an important factor in terms of dealing with these types of cases, is how did the previous administration interpret it versus the current administration? And it comes back to this idea of materiality and scienter. If the company subjectively believed it was doing what the government had asked it to do, that's going to be a huge factual component of a defense to any of those cases. Similarly, if the government was expecting and requesting this types of information from the organization, that's going to be a huge factual point of contention in the defense of these cases. And as we mentioned earlier, pandemic fraud, the PPP cases they're still out there. As we said, there's really sort of a 10-year upper limit on that. So you're looking at probably still through 2031, 2032 maybe is probably where the trailing, some of the trailing PPP cases might end up, because of how those funds were issued, the different tranches of the funds. And really, when you're looking at a PPP case, you're looking at a very interesting concept for the False Claims Act, because usually what you're looking at are claims where those loans were actually forgiven, because the PPP funds themselves were actually private funds. They were actually private loans that were made as private loans pursuant to SBA terms to other private companies. But then the government paid out and the gave the amnesty on those, basically saying, no, you don't have to pay those back now. And that's where you see the False Claims Act potential liability coming in, because that's where you have the government fisc involved, because the government came in and said, no, we're going to pay these off. You're not going to have to pay these. So we'll still see those probably for the next 5 to 6 years. The
Yeah,
civil.
we just on that, Jason, we've seen that even if they're investigating something else, if you were receiving PPP funds, we've seen that kind of as a tack on. Like, why not also investigate whether someone has received appropriately used their PPP funds? So we have about 10 minutes left. The next two slides talk about a couple of the various task forces which are designed to specifically address this kind of discriminatory practices, DEI, and also there's a new task force which was announced just this month in order to address DOJ and with DOJ and Health and Human Services to address fraud or false claims submitted to the FISC for purposes of medical reimbursement. But why don't we go, Jason, if you can skip ahead a couple of slides to the challenges and defenses. And if you wouldn't mind talking a little bit about that in terms of what we're seeing and what potential entities who are facing these allegations, what they should be thinking about in terms of shoring up at the front end.
Yeah, so it comes back to the idea of materiality and scienter again. These are the strongest defenses typically in any False Claims Act case. So you have very complicated government programs with a lot of interaction between the company and the government program, the program officer. So you're looking at two different things. So let's look at, first of all, how are we going to defend this? If we have a case in front of us, what are we looking at? We're looking at what were the interactions between the company and the government. How often were you interacting with them? What were you telling them? What was the government telling you in response to that? So a lot of this information goes again to both materiality and scienter, because if you have told the government what you're doing and the government has said, yes, we approve of that, that is relevant to both the materiality of that information to the government's decision, but it's also relevant to your subjective knowledge, your subjective belief of whether or not you're violating those requirements. So this is the information that tends to be focused on for a long time. You get lots of emails, you get lots of different types of communications. How have you been communicating with the government? And so if you're looking at moving forward now, how are we going to try and insulate ourselves and mitigate this risk? What we saw a lot of people doing, a lot of companies doing in the mid 2000 teens, after the Obama administration started really heavily bringing the mortgage insurance False Claims Act claims, is you started seeing a lot of companies going and saying, you know what, well, I can't certify that I'm in compliance with all these requirements, and here's why. And then the government program officer would say, okay, I understand what you're saying. Go ahead and certify. And at that point, you have a really strong materiality defense. You have a really strong scienter defense. So it's important moving forward. It's important looking backwards, but it's also important moving forward, looking at what do the certifications actually say? What are you actually certifying to? And are there ways that you can work out with the government about your potential concerns about those certifications? So it's exactly what it says here, proactive compliance. Look at how you're actually complying with the program, how you're communicating with your program officers and how those interactions may give you a stronger basis to say they knew, we thought they knew, we told them, and we thought they agreed with us. Next slide. So this is really just going over a lot of the stuff in general again. So you're looking at what are the general defenses we always look at: no scienter and materiality. The public disclosure bar is a very strong defense, but it's not often available, but it's something you have to look at. So that is, has the information, and this only applies to key TAM cases, this does not apply to government cases. Has the information that the key TAM relator is suing on been publicly disclosed through either, let's say, a New York Times expose, through an internal inspector general report, a congressional report, something like that. There are specific types of exposures of the information that qualify. The first to file bar effectively just says that the first key TAM, you're looking at, if you have multiple key TAM cases, a second key TAM relator is probably going to be barred, honestly, by the public disclosure bar, because that other key TAM relator was the first to file. Next slide.
So, sorry,
go ahead, Al. Go.
No. Sorry. You have the honor of presenting the CLE code.
Yeah. So the CLE code is number 2 here, 34902. And we won't spend too much more time here on this slide because I want to make sure we get to our recommendations looking forward. But these cases here, these are some of the primary Supreme Court cases that have really shaped the way the False Claims Act is dealt with today, both on the government side and from the defense side. So if you have any questions about any of these, obviously reach out to us. But the sort of the most important ones here are, we talked about Escobar and should EV supervalue. Those are the materiality and scienter cases. The Wisconsin Bell case is an interesting case, but it probably won't affect that much most people on this call. And the same with Polanski. Polanski was about the government's right to dismiss a False Claims Act claim. Next slide.
So I think we want to kind of end this on a positive note. And I don't know if this is necessarily positive, but as we said at the beginning, the way that the False Claims Act is being used now is very different than it was used 150 years ago, 40 years ago, or even 20 years ago. And one of the issues that has emerged in some of those cases that we just pointed to is this idea of whether the key TAM provisions, particularly, whether those satisfy constitutional muster. And as Jason said, that both in the Polanski case as well as in this Wisconsin Bell case, I call it the Heath case, there was a faction of the justices who chose to articulate that they questioned the constitutionality of the key TAM provisions. And what that means is if they strike down the key TAM provisions, then theoretically the kind of bounty hunting for finding violations that might lead to a False Claims Act case, which we think most of you already know, but that does mean treble damages for however much money was at issue, and there can be a lot of litigation over what the damages are, and it can be in the billions of dollars sometimes, let alone in the PPP, where it would be treble what the PPP amounts were, plus attorney's fees, plus various other costs, including fines for particular specific violations. So that whole panoply of consequences could go away if or at least in form, if the court strikes this down. And if the next slide, there is a case that is now teed up to do just that. And that's the Zafarov case. A doctor practicing down in Florida said that her practice was overbilling to Medicaid. And the judge there, Judge Mizell, decided to find, pursuant to the dicta in the dissent and the concurrence and those other opinions, what Justice Thomas was particularly advocating for, that when a relator stands in the shoes of the government, then they are an executive officer and they have not been appointed as an executive officer under Article 2, and so it's unconstitutional. It just so happens that the current DOJ's chief of staff is married to that same judge, and we are soon to see whether this promise that AG Bondi said that they are going to defend the constitutionality of the False Claims Act, and they have filed an appeal in this case defending it. They are, which is now up on the 11th Circuit. We'll see what the 11th Circuit says. I think the 5th Circuit also, there's a district court opinion now that has echoed this. So we're going to see this issue bubble up. And we'll go to the next slide to do the final kind of recommendation. So stay tuned on the key TAM provisions.
Yeah, so general recommendations, it's really about a culture of compliance, making sure you can not just living it, but that you can demonstrate that you have the policies and that you have the procedures and you've implemented them. It's a huge way to press back against scienter, and the idea that the government oftentimes and the key TAM relator often wants to uh, position themselves as the righteous actor and the defendant as a greedy corporate malefactor that was just violating the law so that they could make more money. Having that top-down culture of compliance helps push back against that standard refrain. And maintaining effective compliance system that is tailored to your industry and your current risks. Make sure you understand the program requirements, what your current program operators in the government are expecting and requiring. Offering effective internal complaint and whistleblower channels and protections. This is a great way for you to ideally deal with the issue before it gets to the government, right? It's the same thing as if you deal with a complaint from a consumer before they decide to sue, before they decide to complain to the government, then you've effectively dealt with that issue much more efficiently, in a much better manner than having to deal with a lawsuit. So having an effective internal complaint system and whistleblower system can help to prevent some of this stuff and make sure too that those whistleblower statements, those complaints don't get memory hold, right? That there's actually some action taken on them, because that's a really effective way for the government, a key TAM relator, to argue scienter in a False Claims Act case, is to have an ineffective whistleblower channel.
And on that point, also, you have to be very careful not to retaliate against the whistleblower, which could be its own separate cause of action. So it's as part of that program, whatever those protections are for the whistleblower, they have to be balanced both so that you get the information, take some action on it, but also make clear that you're not inadvertently retaliating against them.
Yep. And this next one goes really well with the last one too. Conducting appropriate auditing of government funding streams and extra attention on common scrutiny areas. If you're doing effective auditing of your billing, of your funding, then ideally you're going to catch potential overbilling kickback issues before they become an issue with the government.
With that, we'll turn it over to Justin to take us out.
All right, guys. Well, on behalf of Saul Ewing and our white collar practice, I'd like to thank our presenters, Al and Jason, for a very informative, engaging presentation today. And of course, our attendees for their participation. Our team has provided the survey link to the chat box, but please keep an eye out for the thank you email with the program materials and the CLE survey so that you can submit the reporting codes from the webinar. Once again, if the presenters were unable to get to your question during the webinar, they'll do their best to send you a response by email. Otherwise, please feel free to reach out to them. Thank you so much for joining us and have a great rest of the day.